There may well be outrage when people learn that ousted Labour MP Mike Amesbury is back in court already appealing against his 10-week prison sentence for punching one of his constituents. As reported in the Chester Standard here, I'll link below, literally a couple of minutes ago they confirmed that the hearing is underway already. So why the outrage? And what's really going on? And is this really a thing to be outraged about? Well, hopefully you'll stick around for this video. Hopefully you'll subscribe to the channel because I like to bring you these legal updates and help you to understand law on this channel as I've done for about 5 years now, almost every day. So please do hit that subscribe button. And yes, I do ask often. I know I ask often, but it's the difference between about 50 subscribers and a couple of thousand subscribers on a given video. So please do that. I'm really grateful. Thank you very much. So what's going on here and why is he in court so quickly? Now, the outrage is obviously some people are going to say, well, this is two-tier justice. He's back in court already. Why is this allowed? And etc. No disrespect, but you don't understand the system if that's what you think. Now, an appeal from the Magistrates Court to the Crown Court must be made within 15 business days, 15 working days. So it has to be relatively quickly, and therefore it might be heard relatively quickly. And in this case, literally a couple of days ago, he was denied bail on the indication that he was going to appeal sentence. So obviously today he's appeared in court in handcuffs, flanked by prison officers. So let me explain what happens here. If you are convicted in the Magistrates Court, or you plead guilty in the Magistrates Court, you have a right of appeal to the Crown Court. It's an automatic right of appeal. You don't need permission as such to do that, because it's the Magistrates Court. So if you plead not guilty, you're tried in the Magistrates Court, and you are convicted and then sentenced, you can appeal against conviction and or sentence. Obviously, if you agree that you should have been convicted, but you don't agree with the sentence, you can just appeal against the sentence. If you don't agree that you should have been convicted, you can appeal against that as well. And this is then done by way of a fresh rehearing, as though the case is being heard again for the first time, in the Crown Court by a judge and a panel of 2 magistrates. There's an excellent article on Magistrates Blog about choosing those magistrates and the eligibility and so on, which I won't go into here. I'll link that below. Go and check it out. It's a fantastic read. But this will be done by way of a rehearing. The judge in that court obviously will be the expert on the law for the magistrates on the panel. And although it's done by way of a rehearing in the Crown Court, there is no jury. So this is sort of a second bite of the cherry, so to speak, when you are convicted in the Magistrates Court or sentenced in the Magistrates Court and you appeal that to the Crown Court. The interesting thing here is the powers that the Crown Court has in respect of that appeal, which is set out very helpfully in the Senior Courts Act 1981. Under Section 48, appeals to the Crown Court, which you can see here. If I move it across, perhaps you can see it a little bit better. The Crown Court may, in the course of hearing any appeal, correct any error or mistake in the order or judgment incorporating the decision which was the subject of the appeal. And on termination of the hearing, the Crown Court can do as follows. And it's quite a broad power, pretty much anything that the court wants to do. It may confirm the original sentence and say, yep, we think that was fair, leave it as it is. They might reverse it, which means they quash the decision and say that was utterly wrong. We can quash that decision, quash that sentence or conviction or whatever, or vary any part of it that was made, including the determination not to impose a separate penalty in respect of an offence. So, ancillary orders such as banning orders. So, for example, if it's a football-related offence, there's an ancillary order to consider a football banning order. So you must not go to or anywhere near football matches and things like that. Typical ancillary orders. Or if you're fighting in the town centre, an ancillary order that you are banned from the town centre. Things of that nature. So it includes any of those things which are perhaps ancillary to the main decision here. The court alternatively could remit the matter with its opinion thereon to the authority whose decision it's appealed against. It could send it back to the Magistrates Court and say, think again and make another decision. That's unlikely in this case, but it is a possibility. Or make any other such order in the matter the court thinks, but such order exercise the power which the said authority might have exercised. In English, that means the Crown Court could impose a different sentence, so long as it doesn't exceed the powers of the Magistrates Court in the first place. So it couldn't, for example, sentence to a much greater sentence than the magistrates would have been able to impose in the first place, but it could increase or decrease as it thinks fit that sentence which is being appealed. In this case, the 10 weeks. Clearly, in my view, Mike Amesbury and or his lawyers, I say and or his lawyers because if he instructs his lawyers to make the appeal and there is some, he's got the right of appeal they will do so, and they will put the arguments forward. It's not their job to believe whether it's right or not, so long as it's not completely unarguable. And in this, in cases like this, it's not completely unarguable. You could have had a severe community order and fines and things like that, which might have been sufficient in some cases. Many of you probably think that's not sufficient in a case like this, but I'm not commenting on the case as such. It's just open to interpretation. So he will make that request of his lawyers to appeal, obviously because he doesn't want to go to prison. He will be angling for a non-custodial sentence, i.e. either community order or fine, or perhaps suspending the sentence, and he might do so on various arguments of mitigation and so on. So that is what he is arguing. I don't think there's going to be any update just yet because the hearing was just underway a few minutes ago. They are reporting live as I'm recording this. Incident recap. Judge Everett is hearing the case. He's now listening to the prosecution barrister, Gareth Roberts, who is setting out the offence that Mike Amesbury has committed and was jailed for. The incident in October last year where Paul Fellows saw the defendant, Mike Amesbury, who recognised on a number of levels as his MP, but also from his community. The conversation between the pair was described as passive, with Mr Fellows having his hand in his pockets. That the convicted Amesbury then began to attack his victim. The court heard that Mike Amesbury punched him a number of times with the now famous quote of, "You won't threaten your MP again, will you?" And this CCTV is being shown to the bench as we speak. So obviously the court's going to make a decision on this, either to confirm it as it is and say that was fair, there was no error in the way that the court approached that sentence and reached that sentence, which I think is reasonably likely. It's reasonably likely that it will just stay as it is. Secondly, it could quash it and set it aside, which is doubtful. Thirdly, it could remit it back to the Magistrates Court to make the decision again, which is doubtful. It'd be a waste of court time. There's no reason to do that. Or alternatively, could replace it with an alternative sentence, which could be more or less harsh than the 10 weeks that he was given. But interestingly, and just somewhat buying time here because I'm waiting for updates on this page, but in 2019, there were 3,432 appeals against sentence to the Crown Court from the Magistrates Court. And out of these, 1,705 appeals were allowed, which is 50%. So 50% of these appeals were allowed, meaning the court either just set the sentence aside or quashed it and replaced it with an alternative sentence. A brief update on this report. The court is now watching this incident on the screen. As Mr. Roberts is explaining various points, the offences that led to Mike Amesbury's conviction. It shows that Mr. Fellows was pushed back by Mike Amesbury, who proceeded to rain punches on him, as quoted by Chester Standard here, before other people intervened. Mr. Fellows remained on the floor, and then the footage ends. Mr. Roberts then asked the court to show secondary footage where the MP returned to his victim to shout at him. Chester Standard writes that Amesbury is not enjoying the rewatch of the footage, that he would have been shown multiple times by the police, the magistrates, and now the Crown Court. Obviously, watching over and over again that you're accused of doing is obviously not a comfortable thing. It says his eyes are down as they return to the screen fleetingly. Mr. Roberts tells the judge about the no-comment interview following the prepared statements that he'd set out, that he'd been screamed at over local and national matters. He said that he was about to be physically assaulted and that he was terrified and needed to defend himself. So it'll be down to the judge whether he accepts that or not. Further update, Judge Everett tells Mr. Roberts that there's a discrepancy between the statement and the CCTV footage. It doesn't seem to match at all, he said. The judge asked why there wasn't an affray charge and follows to say that this was an assault in a public place with abusive words and followed up to a man who was defenceless. The judge is thinking out loud about the incident, they report, and I'll link this below, by the way, and highlighted words spoken by a witness to the incident who told the MP that he was going to lose his job. She's pretty much spot on. Quoted by Chester Standard here. So with that, I hope you found that interesting, but I'll probably be back when there's a result to this and give you my reactions. But please do subscribe for that, and as always, thank you for watching.